Good, Vachas, Gabriel Jackson, and welcome to BJC Mitzvah Day, number 58, part 2, using the Sefer HaChinuch. A Mitzvah Day keeps us all on its way. Hope everyone had a wonderful Shabbos. And once again, we're continuing with the obligation upon the Beis Din in the court to judge cases of civil litigation dedicated to our holy idea of soldiers. They should be successful in eradicating the evil. Okay, the Chinuch qualifies this rule, as we talked about, how a person admits to part of the payment that he might owe, then he has to make an oath, but if he denies the whole thing, he's off the hook. Let's see. But concerning the type of claim typical of custodians, which is the claim of an unavoidable mishap or the claim of theft, even if the custodian does not admit to part of the claim, but rather says that the entire deposit was lost on account of an unavoidable mishap or that it was stolen, he is obligated to swear. The Chinuch thus concludes, and although only the specific case of partial admission is addressed, nevertheless in this verse there is encapsulated the command to judge all of the monetary claims that take place between people, which involve admission and denial. The underlying purpose of civil law is well known, as again he mentioned many times. We need a civilized court and to judge cases, otherwise society will eat each other alive. The laws of this mitzvah are numerous. The Chinuch begins with laws pertaining to the case of partial admission. They include, for example, the law that one who makes a partial admission of liability is required to take an oath under biblical law to confirm his denial of the remainder as mentioned above. The definition of a partial admission that generates an obligation to swear is one admits to liability of at least one peruta, which is an amount of money, the smallest coin, and denies liability to a minimum of 2 silver ma. So he says here in the commentary, a peruta is a copper coin equal in value to half a barley corn of silver. A silver ma has the value of 32 perutas. Hence, 2 ma contains 64 perutas. In order for the defendant to incur liability to the oath of partial admission, the plaintiff's overall claim must be for at least a value of 2 ma and a peruta, which means 65 perutas, and the defendant must admit to at least a peruta of the claim and deny at least 2 ma. Interesting, okay. But concerning a case dealing with less than this amount, the defendant is not required to take an oath under biblical law, unless a single witness testifies against him, in which case the defendant is required to take an oath even if he denies liability concerning an amount that is less than 2 silver ma, as long as the amount is at least a peruta. But concerning an amount that is less than a peruta, one is never required to swear, unless the plaintiff claims from the defendant utensils, for in regard to claims involving utensils, even if the plaintiff claims from the defendant 2 needles, and the defendant admits to the liability of one and denies liability of the other, he's required to take an oath, right? Because even if it's less than a peruta, the value of 2 needles, still he's admitting the partial of the needles, one of those 2 needles. Interesting stuff. A lot more to be said about this mitzvah. To sponsor a future mitzvah or to be part of our Chai Club, just click the link below, and we'll see you tomorrow.